Hello everyone, this is Julie Maselli, partner in Husch Blackwell's Higher Education Group here in our Chicago office. We are excited to give today's presentation on the day-to-day risks of having minors on college and university campuses, as well as providing strategies for assessing and mitigating these risks. Before we begin, I'd like to cover a few housekeeping items with you. At the bottom of your audience console are multiple application items for your use during the program today. I'd like to take a minute to highlight a few of the key icons for you. If you have any questions during the webcast, please submit your question via the question box. We will try to answer all questions during the webcast today, but if a fuller answer is needed or if we run out of time, we will answer all questions later via email. We truly appreciate everyone's participation and encourage you to submit questions, and if we can't get to them, know you'll be getting an email from us in the coming days ahead. If you have any technical difficulties, please click on the Help icon. It has a question mark and provides information regarding common technical issues with our system. A copy of today's slide deck is available in the Resource List icon, and that looks like a folder at the bottom of your screen. We've also included a recent journal article that myself and my co-presenter, Ashley Morpo, drafted for URMIA, the University Risk Management and Insurance Association's annual journal. This was an article titled "A Risky Business, Managing the Day-to-Day Risks of Having Minors on Campus." So if you're looking for additional resources or context, I'd recommend you take a look at this article or go to URMIA's website for more information. To report your this program has been approved for Colorado, Illinois, Iowa, Missouri, Nebraska, Tennessee, Texas, and Wisconsin continuing legal education credit. So for those of you who need CLE credit, again, Colorado, Illinois, Iowa, Missouri, Nebraska, Tennessee, Texas, and Wisconsin. To report your hours in Illinois, Nebraska, Tennessee, or Texas, click the CLE widget at the bottom of your screen and complete the questions. A recording of the webcast will be available tomorrow for watching and for sharing. Once available, a link to the recording will be emailed to you along with a certificate of attendance. Joining me today is my colleague in the Chicago office, Associate Ashley Morpo. Ashley focuses her practice on litigation. Prior to joining the firm, Ashley was an Assistant Attorney General at the Office of the Illinois Attorney General. In that role, she prosecuted claims on behalf of the Illinois Department of Labor, gaining significant trial experience. Again, my name is Julie Maselli. I'm a partner here in the Chicago office. I have worked on minors issues for a number of our university and college clients. I also served as in-house counsel at Northwestern University before joining the firm, where this was a primary area of my practice. Prior to coming to Husch and to Northwestern, I was Deputy General Counsel at the U.S. Department of Education. Our Chicago office is really thrilled to be having this webinar for you today. And now that we're done with the housekeeping, let's get into the good stuff. I just want to note that since we're all in Chicago as we're hosting this here, we just added 6 additional attorneys to our group, and we know a few of them have joined us for the webinar online, and I want to welcome them. We're very happy to expand our Chicago higher education practice with those 6 attorneys, and just a shout out to all of them. So let's get into our presentation. So after Penn State University and the controversy with the Jerry Sandusky matter, higher education really mobilized very quickly and jumped on evaluating its own policies for mandatory reporting of abuse and neglected minors and children. For institutions that did not have a policy, institutions started drafting them. For institutions that did not have acknowledgement forms or training for staff, they started putting those together. And the industry really addressed this key risk area of how do we report to child services if we have a suspicion of abuse and neglect. And that is one very important risk factor, but it's only one of many that institutions have to consider when they invite their minors on campus. And there are many more day-to-day risks that program staff who work with minors have to deal with. In our experience working with higher education, where internal controls can sometimes be decentralized, and where youth programs can often sprout up organically to meet a new need, it can be very difficult to provide guidance and counsel and standards for all of those programs. We have seen a lot of universities and college clients have sort of the approach of 1,000 flowers bloom, so to speak. And a lot of these programs provide very important services and fill demand. Faculty may work with youth to experiment on promising education reforms. The institution may offer youth mentoring and training to give back to its surrounding community. And there can be real tangible benefits for the institutions in offering these programs. It gives them an opportunity to expand their brand, to build their relationship with the broader community, to provide creative work experience for its students and its graduate students, and even to supplement revenue. So ultimately, to achieve all of these underlying goals of these minors programs, institutions need these programs to be of high quality, with high satisfaction, and with few problems. That also means that institutions need to identify and mitigate the legal and reputational risks that program staff working with these programs deal with on a day-to-day basis. And that can be really hard where these large programs go from small ones and where there may not be direct oversight by central administration. And in our experience, sometimes there isn't even awareness that the program or activity serving the minors is even occurring at all. So with that said, how do institutions provide support to those on campus who work with youth programs, especially where programs differ so much and a one-size-fits-all approach may not be adequate? In other words, how do you mitigate risk without stomping on all those budding flowers that may be serving an important purpose? And I wanted to start with these opening remarks because we get a lot of institutions asking questions about this, and I think they're fearful that the best way or the easiest way to mitigate risk is to close down these programs. And what we like to do is try to take a flexible approach, that a lot of these programs are being offered, and there are real legal and reputational risks facing the institutions by offering them, but they've been occurring for a long time, and there's value and need that they are serving. And so what we try to do is create a clear path so that these programs can be offered with less risk. So we're going to try to answer these questions today and also try to identify some risk strategies. So let me quickly go over the agenda. Through with you an initial recommendation that we provide to institutions about conducting an inventory of minor serving programs for those of you who are just getting this work started. We're going to go through a few pending cases, nothing that would surprise you, about what's out there, what kind of lawsuits do institutions typically face involving their minors programs. We're going to spend most of our time covering key risk areas. We know that this is the area I think that we will get the most questions, and so we'll try to save most of the time for these risk areas and also provide you some strategies for mitigating those risks. So in our experience, the most commonly occurring programs that we see on institutions, or being offered at institutions for minors, are often academic enrichment programs, and that may be testing support services or gifted and talented programs, academic programs, math camps that may occur over the summer or throughout the year. Another really popular area, and perhaps the most popular offering, are athletic and music camps and clinics. A lot of coaches at universities and colleges will host these camps in the summer. They often attract a lot of attendance, sometimes even beyond the local area. And then also mentoring and tutoring programs that the institution sponsors. But we also see a number of other programs and activities out there that go beyond the more commonly known programs. There are maybe programs organized by unaffiliated third parties, folks completely unrelated to the institution, but that are being held on campus for minors. There are also unofficial mentoring and tutoring programs that we see where faculty, staff, or even students or student groups are creating a relationship with community members to provide unofficial mentoring to minors who may be coming on campus or who may be getting served off of campus. There's maybe unofficial tours and visits organized by faculty, staff, and students. There are all kinds of sponsored events where members of the public are invited in, which may include minors, theater productions, and athletic events are examples. And some institutions even have their own sponsored daycare. With the variability of the kinds of programs that are out there, we recommend that institutions looking to tackle and mitigate risk in this area first conduct an inventory. We have found that schools may be well aware of the athletic camps that are going on, but there may be a number of other programs that are actually quite similarly situated or run very similarly to those camps, that if we're trying to address and create standards for them, we may want to include them in our analysis. So what we recommend is trying to do some surveying work to bucket the kinds of programs or program categories that you may be offering. Are you offering activities serving minors exclusively on campus, or do you have folks that are going out into the community from the institution and using the institution's imprimatur to provide services to minors? Are you providing residential or overnight stays for some of your minors in these programs or activities? Or are you only and exclusively offering non-residential, where minors are coming onto campus but then going home and not staying over the night? Are these all sponsored programs? Are they non-sponsored? Do we know? That's actually an issue that we see often, is that we have these camps, we have these programs, but institutions may not really understand whether they're sponsored by the institution or not. They may not have, or there could be a real blurring of the lines as to who's actually responsible for that program, an outside party, a faculty member, a coach, or does it all roll up under the institution? Regularly offered versus one-offs. If we're trying to think of standards that may apply to categories of programs, we may apply certain standards differently to programs that are offered on a regular basis than we may for a program or activity that simply happens one time. When you've got the inventory in front of you, there's a couple of sort of natural questions that I think a lot of institutions may be asking themselves. One, should youth programs be subject to institutional approval? Or is there sort of a central way to bless the program as it's getting off the ground, or even to go back and sort of identify those programs that are sanctioned or sponsored by the institution? For those of you who deal with student groups, this is sort of a similar analysis. I know a lot of you are dealing with, is this a recognized student organization or a student organization that's really not under the umbrella of the institution? The analysis is really the same here. We're trying to figure out if the program is sponsored and approved by the institution. And another question that often comes up when an inventory of these programs is available are the cost-benefits analysis that I think is natural. Do the benefits of the program outweigh the risks and the resources that the institution may be putting into carrying them out? When you have that inventory, this is, to me, probably your best roadmap of how you might try to start prioritizing your approach and trying to figure out what kinds of standards you may be able to apply or resources you may be able to apply to program staff who are operating these in order to mitigate risk. But I want to also note that there are a couple of other areas or activities where minors may be involved, and this may not be your top priority as far as trying to mitigate risk, but I didn't want to gloss over them or not mention them because they are important areas. And you may want to consider whether your institution should be addressing these either through policies or procedures as well. Some of these areas are academic programs that the higher education institution is offering, but where minors are enrolled for credit, dual enrollment. On-campus events that are open to the public may have members of the public, including minors, on campus. Do you have any policies or procedures or need extra protections for them? Campus tours or visits for prospective students or family members is another area where we have minors frequently coming onto campus, sometimes with families and sometimes on their own. And then another area are research programs that are subject to approval and review by the Institutional Research Board. For those research institutions out there with IRBs, you should have specific provisions in your IRB policy that govern the research involving minors. That as a vulnerable population, there are requirements on IRBs specifically with respect to research there, and so I wanted to note that this is a related area, and potentially it could be a carve-out area. If you have good policies and procedures regarding how those minors are engaged in research studies, you may want to carve them out from any broader minors policy that you are thinking of adopting. And finally, for extra credit, for all you academics out there like myself who is always trying to get that extra point, I'm a self-professed nerd, I can tell you that there's some policy guidance that we have received from a number of institutions that regarding the benefit of this. It's a little outside the realm of legal, but I think it's really worth sharing because there's value here. When you conduct that inventory, you may be able to identify a number of synergies that the institution may not be aware of. For instance, you may find that your programs are serving similar populations or even the same populations or areas. You may be able to spot duplication. You may be able to also see where you have some programs that you could be bringing to scale and supporting in a more robust way. And all of this may raise potential for grant opportunities. There's a lot of grants out there looking for programs that are focused on enrichment and improvement of minors. And so your programs may be really well suited for applying for grant opportunities. And so as a partner to you all, I wanted to make sure I was mentioning this. So as you're thinking about those synergies, you may want to consider whether there's data that you should be collecting as part of your inventory about those programs. Are those programs serving underrepresented groups, for instance? Are they serving, or do they have a focus on STEM? Or growing your institution pipeline? Are a lot of your students coming to you through the enrichment and academic or athletic programs and music programs that you are offering while they are minors? Availability of outcome data. Some of these programs were happening, they started organically to meet a need. They took root within the community that is now relying on those programs. But there may be more than just anecdotal information about the effectiveness of those programs. And some of those programs may have a very specific academic goal in mind and maybe collecting data on that. And knowing what programs have data may help you analyze where you may want to try to scale programs up. And then another consideration is the revenue versus the resources spent. Are these programs financially sustaining themselves? If not, is the value such that we continue to support it regardless? And how many are being served? So I take a little bit of an aside there and on the non-law, but Ashley's going to get us back into some of the legal aspects of the risks that we consider by providing you a bit of a summary of some of the more recent personal injury cases that we see out there.
Thank you, Julie. Yes, as you all know, personal injury lawsuits are very common. Are commonly faced by various universities. For example, most recently, the University of Miami faced a litigation regarding a minor who sustained a bone fracture during a summer camp with allegations of negligent supervision. Similarly, a parent who sent their child to a cheer camp at the University of San Diego has made similar allegations stating that the university failed to provide staff members with required safety training and also failed to provide minors with sufficient information for them to be safe while engaging in the cheer camp at the university. And as PI is the most common area of litigation that universities face, addressing those issues is typically done by having a liability release.
So institutions, hopefully, who are offering these programs have some form of a liability release. And we see all kinds of forms, and it's pretty typical for us to take a look at these releases. And I certainly want to mention that public institutions may be protected from some of these lawsuits under qualified immunity. And so not all of these lawsuits are really going to progress, but certainly institutions progress towards some sort of damage award, but we do see that. We certainly do. But institutions certainly are good and targets of litigation. They have deeper pockets than individuals, and there's really nothing an institution can do to try to prevent itself from getting sued. And so we do see most commonly the personal injury cases involving minors on campus. But liability releases are a good first step. One of the things that we typically want to see in a release that we often revise these releases to include is not just a clear waiver, but also an assumption of the risk statement. But I want to mention that in some states, broad liability waivers may not be upheld. So we always want to have these because the absence of a release, I think, can be difficult to overcome. But if you have some damage or harm that befalls a minor, you want to have that as a backstop, but I don't want institutions to feel that they can over-rely on a good liability release. About a dozen states regularly enforce waivers to protect schools. But nearly 20 routinely reject enforcing them against schools. The issue is a little less clear for the remaining states where there is uncertainty as to whether a state court will enforce a waiver to protect a school. And so given that, we certainly want to see a strong liability waiver, but we prefer the strategy of prevention over protection. And we think a smart and safe program administration is the way to go, and ultimately it helps you accomplish your most important goal, which is providing a good quality experience for your minors. So Ash is going to talk about a couple of the key areas, the risk areas that cover to start, and she's going to focus on supervision. And supervision may seem like a bit of a no-brainer that we need to have adequate supervision for our minors on campus. But it really does go way beyond just having enough staff to the minors and having an appropriate ratio. We see all kinds of other areas where supervision needs to be considered, and so Ash is going to walk us through a few of those.
Yes, thank you, Julie. When thinking about the risk area of supervision, you need to think about the supervising minors' activities as well as who's supervising the minors. And particularly what has become I guess, a hot button issue is supervising minors' activities on the internet. With today's technology, day and age, students have access to their laptops, university computers, as well as cell phones. What we're seeing is that students who participate in these minor serving programs are on campus, and they do things such as download copyrighted materials and using the internet to download music, videos, and inappropriate content such as pornography. Universities should be wary of this because even though the minor is engaging in unlawful conduct, the institution or the university is most likely to be targeted because, frankly, the university has probably more money than a 7-year-old. In addition, we are seeing minors using the internet to bully other students, uploading inappropriate content to social media, and also minors are being contacted or contacting other individuals while on campus to solicit sexual activity. It's also good to know that there are some federal and state regulations that govern internet use for minors. Though these laws are directed and applied to school districts and other public institutions, it's good for universities and colleges to know what those laws are and consider those laws when drafting appropriate policies to serve your minor serving programs. In regards to developing policies to address minors' use of internet, the 5 points here are common policy elements that are required by school districts and public institutions that we are seeing, and we present them to you for consideration as you are developing or reevaluating your policies. One of the 5 major elements are minors' access to inappropriate content, safety and security of minors when using email, MSS, and directed communications, hacking and other unlawful activities by minors, unauthorized disclosure, use, and dissemination of personal information, and measures for restricting minors' access to harmful materials. Again, we present these elements to you as something to consider and balance these elements with your own institution's values and make sure that these policies and the policies that you develop for your minor serving programs are in line with your institution's values. The next area of supervision that we want to discuss are the coming and goings of children. With today's technology, we tend to focus on minors' online activities, especially with so much media attention drawn to it, that we sometimes forget about their offline activities. And we want to make sure that your institution has appropriate policies in place to cover the risk areas associated with minors' offline activities. The biggest risk is the coming and going of children. You want to think about who's dropping the kids off. Are they coming to the program by themselves? Who is picking up these students? These are all things that your university and institution should be considering. When developing standards, you should consider age-appropriate standards for parent-guardian pickup, mid-program pullout, and again, standards for students who are transporting themselves to and from the program. Also, you should be thinking about and reevaluating your missing minors protocols and make sure that your staff and employees are well aware of these procedures and policies, and there's adequate training on how to use and implement these policies and procedures.
Another area of supervision, and one of the key areas of supervision that we want to cover are the adult participants themselves. Often the quality of a program is only as good as its program staff. And a lot of institutions are really lucky in that they have really capable and highly qualified program staff who have been working with minors for decades. It's been our experience that a lot of these programs have a lot of really skilled, knowledgeable folks who may have had experience in the K-12 arena or who have focused their career in this area. And yet it's still important that the institution does have the appropriate backstops for dealing with personnel issues that may arise in these programs. Given that the minors are the population being served in these programs, it's really important that any contract that you have or agreement and personnel agreement that you may have with these staff really highlights their requirement to comply with all applicable laws and policies, including any minors policies or guidelines that you may have or have adopted, and that there's a code of conduct for adult participants, explaining specifically their your expectations for their conduct and potentially covering issues such as boundaries, personal space, one-on-one activity or connection with students, use of social media or electronic technology to communicate with students, transporting students. Code of conduct can be pretty broad, and there's a lot of areas that we may need to get a little bit more specific about so that adult participants who are trying to do a good job by students or by minors have clear expectations from the institutions about what they should be doing and how they should be doing it. And then, of course, we want to structure these employment relationships or independent contractor or volunteer relationships with these adult participants in a way that it's very clear that serving in these programs is a privilege, and it is a different component than if you're serving as a staff member or faculty member with the institution, and that if there are compliance issues, that personnel will be promptly and immediately removed from these programs. That is a pretty dicey and tricky HR issue that we do recommend you consult with legal on, but we like to see some really good template language around these topics. The key area that I think a lot of institutions really struggle with is background checks. We do recommend that institutions consider doing and do background checks for individuals who are working directly with minors. But we do also recognize that that raises all kinds of issues with respect to, well, what if those participants or those program staff also are, for instance, faculty, and we may not background check our faculty. Another big important question that needs to be addressed is what do we do with positive results and what are we looking for? Are we looking for minor drug offenses from a long time ago, or are we looking for certain kinds of trust and maybe minor-specific crimes or offenses that we need to be aware of in order to filter out our staff? What is our process for doing that? So we know that background checking is not as it's easier said than done, but we do think it's a very important protection, and there are variations of the kinds of background checks that you can conduct. We also recognize that there is an expense associated with this, but we think from our perspective in limiting legal risk that this is something that is absolutely worth considering and doing. And then, of course, what does adequate adult supervision look like? We may have the exact right people that we want servicing minors who have the right background check and are complying with our code of conduct, but do we have enough of them? Do we have the appropriate ratios for minors to staff? And that may vary based on residential program or day program. You may need more staff for residential program. Or depending on what you're doing during the day, there could be variation there as well. And of course, all of this might be age appropriate. So there are resources out there, and even some states provide guidelines on minors to adult ratios for things like camps. The American Camp Association has developed some guidelines and recommendations, and so one of the things that we recommend is that you look at these as a source of guidelines because one size may not fit all or even similarly situated programs, but the guidelines can give you a jumping off point as to what's appropriate for certain age minors.
And lastly, under the umbrella of supervision is mandatory reporting. Unfortunately, when incidences occur, you want to make sure that your institution or university has policy in place for reporting those instances. Make sure that you have a policy on abuse and neglect. Make sure there are acknowledgement forms that employees sign. Make sure that there is employee training and that all employees and staff members attend. And make sure that you provide those policies and procedures to third parties who may be coming onto campus and interacting with minors while the minors are on campus.
Thanks, Ashley. So another big area we get a lot of questions is medical information. I'm just seeing we're having a delay, so I apologize if you're getting the slides a little bit late. We're going to try to fix that as we're going through. So hopefully everyone has the medical information slide available to them. This is an area we get a lot of information, and some of the medical forms we see out there we get asked to look at. It looks like somebody may have gone onto a website and looked for sort of a resource, or what is another institution doing, and maybe taken that form, and that's what we're using, and we're asking a lot of medical information about our minors. My recommendation is that we need to be much more strategic as an industry about what we are asking for and how we're using that information. And most importantly, how are we protecting that information? Most schools, higher education institutions, will extend FERPA, which we know all applies to higher education institutions, for their students to minors on campus and the records that we maintain on them. And so those FERPA protections would then therefore apply to health information that we may be collecting on our minor students. But what we find is a lot of that medical information may be in file cabinets in various different components of the institution, some within the athletic department, some within the, these minor enrichment programs, some within a faculty member's own office. Wherever these records reside, we need to make sure that the folks that are those record keepers have some around privacy and confidentiality and even records destruction. Those are the kinds of things that we may not hang on to forever, consistent with your records destruction schedules. The medical history, we see a lot of requests for more information from students, but some of that is absolutely relevant and important for those kinds of programs where that's necessary. But then there are also other programs we're asking for a full medical history for a Saturday SAT prep class may not necessarily be needed. And so we want to be strategic about where we're asking for this. But where you're going to have students working or minors working together in close proximity with each other, especially if they're staying over, one of the areas of oversight that we see is thinking about immunizations and required immunizations. Most schools will have some requirements for the higher education students that are coming on. All K-12 schools will have these, and states have their own sets of laws around what required immunizations you have. For those of you who have access to a health or wellness center on campus, there's probably a lot of expertise for you to bring in to consider what kind of immunizations maybe we want to be requiring, what's already required by the state, so we're not going necessarily beyond what state requirements are, but so that we're ensuring that the minors that are participating in this program have what they need to keep everyone safe. And of course, what are we going to do with that information if we have a medical emergency, and where is that information housed? I just want to, since we're talking medical information, I'll just make a note here. There's, maybe dispel a myth, I think there's a lot of confusion out there. Hopefully this is clearing itself up over the years that we've been addressing this, about HIPAA's application to medical information that the school may house. This can be a tricky area, but typically medical information relating to students that may be collected in this way, or minors, is not going to be protected by HIPAA because as the school owns it. Because the institution of higher education isn't a HIPAA-covered entity. If there are any questions about this, and there can be some exceptions to it, I would suggest consulting with an attorney, but HIPAA does not just protect all medical information out there in the world. It does protect certain medical information held by certain entities. And so I just wanted to note that that's a common myth in higher ed, that HIPAA just applies to all information. So when we're thinking about the kinds of authorization forms that we may be looking for students who are from their parents, for minors who are participating in these programs, there are two in particular forms that I like to see. A medical treatment authorization form. What can we do if your student or your minor is, for instance, staying over the night, and that student has a fever? Is that we send all students home? What kind of medical treatment may we be providing? Obviously, I hope it's obvious that this medical treatment would be just to address minor issues. Certainly, we would not be providing clinical treatment to minors. That is not what that kind of an authorization form is, but possibly tagging into the administration of medication. Would we be offering or providing over-the-counter medication to a student? If we are, that really needs to be documented. That is an area that does make me nervous as an attorney, that we want to be very clear as to what, if anything, the institution will be doing, and that parents are aware of that and have signed off on that. The medication administration, this goes beyond just what a student may feel. For instance, if you have a high school-age student who wants to take Advil for a muscle soreness, that's one thing. But what about those students who come in with prescription medication that needs to be administered? That's the kind of thing for a lot of programs, particularly residential programs, that staff need to be aware of, and we need to have sign-off from the parents, particularly if there's any involvement by institution staff in the administration of that kind of medication. One of those areas that we're seeing in particular administration of medication is with the use of EpiPens for allergy issues. There's serious allergy complications, and EpiPens can be a life-saving treatment. And so a lot of institutions are and sort of following the lead from K through 12 school districts who have EpiPens available and on site, and have folks who know how to use them and that will administer them in the event of a asthma or allergy-related emergency. So if that's something that your programs are considering, I definitely recommend adopting a policy and procedures and providing training so that folks who are doing that are knowledgeable. And of course, all of that information needs to be protected as confidential. We've covered that for medical information, but there's other student information that the institution of higher ed also should be caretaking. It can be very tempting to use minors' information or likeness in promotional materials and handbooks. And we would like to see, just as we would with our higher education students, we'd like to see a release used there, so that that information related to the student can be used. There is a greater sensitivity, not that the law looks at this any differently, but there is a greater sensitivity with respect to the use of minors pictures, particularly on social media. And so that's another area that staff may need to be trained that, Facebook page about the activities of their minors programs may not be the appropriate place to be putting pictures of minors, and there is a lot of sensitivity with parents about that.
Another area of risk that universities and institutions should be considering is the area of inclusion and accommodation, specifically with sex discrimination, as the legal landscape around LGBTQ rights have changed, particularly in the Seventh Circuit. A recent case, Whittaker v. Kenosha, has come down in which the Seventh Circuit held that a policy that requires an individual to use a bathroom that does not conform with his or her gender identity violates Title IX. In addition, the court went on to state that subjecting transgendered students to different rules and different treatments also violates federal law. You should be cognizant of how the circuit in which your institution is located is treating LGBTQ rights. In addition, the issue of disability is something that universities should always be cognizant of. The Americans with Disability Act, as well as Section 504 of the Rehabilitation Act of 1973, prohibits institutions from discriminating against individuals with disabilities and imposes obligations on institutions to accommodate individuals with disabilities to ensure equal access to its offerings.
What I'd say here for everybody is that we are very familiar with how these requirements and laws play out with respect to our higher education student body. But there is an extension to minors that we serve, and there can be a different set of expectations as to what those legal requirements may be for parents and for their minors and the institution. A lot of students with disabilities have been identified by their K-12 district as having that disability. They may have an IEP or individual education plan put in place. There's a federal law, IDEA, the Individuals with Disabilities in Education Act, that ensures these kinds of protections for K-12 minors at their school districts. That law does not extend to higher education. But parents may not understand that. They may be getting services for their students or for their minors that they would expect the institution of higher education provide. And so it's often that reason alone, that disconnect and misunderstanding as to what the institution of higher education is required to provide, that generates a lot of questions. So what we recommend is that the institution adopt a disability policy that applies specifically for minors, and that institutions consider whether they will accommodate requests for transgendered accommodations as well. Obviously, these are not the same issue. They are related to accommodation, but we're seeing this pop up in minors programs, sometimes even more than we're seeing on a day-to-day basis with our higher ed student body. And so these requirements do apply. But I'll note that the disability requirement applies a little bit differently. This is a nuance of the ADA with respect to academic programs that the institution of higher ed may be offering versus enrichment programs or athletic programs. I mean, the key here is that minors who are accessing programs can access them and can participate. The standard is not the same as under the IDEA. It is significantly less. But we want to make sure that we are complying with these laws. And so I don't recommend that institutions just simply rely on their disability policies as they apply to their student body, because I think there are unique issues here for these programs that are privileged programs for minors to be participating in, and yet we want to make sure we're balancing that and providing access to those students and not discriminating against them. So another area that we can see that we're seeing an increase of issues are behavior and discipline. A lot of minors programs, particularly those academic programs that are sort of structured as a mini school, either for after school, before school, or over the summer. The behavior and discipline issues are becoming more challenging for the program staff who are managing those classrooms. And the discipline policies of the institution do not apply neatly to minors who are not necessarily age appropriate for minors. So we do want to make sure that the disciplinary procedures for minors is spelled out. Now this may be some form of expedited process, but we do still expect a fair process. And it may be a matter of students following a code of conduct, and if they violate that code of conduct, that there are some swift consequences for minors who are participating in these programs. But we need to explain to parents who's making that decision, when is the parent being notified, what those potential sanctions are, and if it is removal from the program, are there refunds for some of those fee-based programs or not? It's important to have this outlined in a policy so that program staff who are dealing with the behavior and discipline issues have something to follow so that they're applying these procedures consistently. And it seems to be an area that is often overlooked with these programs. Another area that we see a number of questions coming in are the involvement of parents with these minors programs. I know every higher education institution may have the occasional helicopter parent asking questions about their majority-aged higher ed student. But when we're talking about minors, we're seeing parent involvement at a much more increasing rate, and that's to be expected. But we need to have some parameters for parents' participation in programs and their involvement. And so having that in writing can give program staff a nice backstop and a nice resource to go to when they're dealing with parents asking for more than they're able to provide. So in order to facilitate parent involvement in a more controlled and manageable way, we'd like to talk about parent observations in a policy. Are they permitted, and if so, when, and how does the parent go about scheduling those? Are there any limitations on the number of visitations or observations? If parents want to participate, can they? What are the expectations for parents and guardians with respect to their own conduct? Sometimes we have seen maybe an overzealous parent here or there creating some issues within a program, and so if they are going to be participating, there may be conduct expectations. And these may be awkward conversations to be having, so having something that's sort of generally applicable to all of these programs, again, really can be a good, useful backstop for your program staff. And then the key area where your legal offices and your outside legal counsel is likely getting questions are a growing number of questions around parent-guardian custody issues, particularly with respect to a student or a minor coming and going, coming to the program, leaving the program, and getting picked up mid-program. It's important that we have clear understanding, as Ashley talked about who is going to be picking up a minor. And those requirements really may differ for the age. High school students may be able to come and go without the supervision of a parent or guardian, but younger students may not be necessarily released by the institution until there is a parent or guardian present. We need to know who that person is, and program staff need to know what do they do if someone else comes to pick up those minor children. So I want to talk a little bit about strategies and tips because some of this may feel a bit daunting. It's almost like applying the layer of rules and requirements that a K-12 district may have to follow to your athletic camp. Well, can one size fit all? I don't think so. I think that there are guidelines that a school can put together for these kinds of programs that puts it on the program to say, these are the kinds of areas that need to be addressed and need to be considered. And I would say that all of the risk areas that we've covered in today's webinar are applicable to all of these programs. They just may be applicable in a slightly different way. And the way, I think, to administer your youth protection program in a way that's manageable is to try to categorize and try to group those together. You may treat your residential programs differently than your camps, than your enrichment programs. But once you have those categories, you want to have either policies and procedures that are required on those programs, or at a minimum guidelines that at least provide those program staff with resources and sort of a backstop or benchmark from where to go and how to address those. I like to see institutions take a sort of customer-friendly resource approach, that this is something that the institution can provide to these programs to help them mitigate risk, and so that they don't feel that they're out there on their own. But every institution is going to have to deal with this differently. Some institutions will have the ability to have this all centralized within their central administration, and some will actually need the program staff to run with all of this. So depending on your size and your resources and your ability to have someone dedicated to looking at these issues for your program staff, institutions will have to deal with these differently. But every institution is going to need to prioritize. The areas that I think are maybe the easier lists for institutions would be addressing third-party programs. Where do you have programs that are being hosted by outside parties, that are not sponsored and not hosted by the institution, but rather are accessing your space and being held on your campus, perhaps through a facility rental agreement? Is your facility rental agreement covering all of these issues? Do you have a broader minors policy that you're directing those third parties to and saying that you're responsible for complying with these? If not, that's an easy place to go, and then you're at least making sure that outsiders coming in have clear expectations of what's required, and you're creating separation between yourself as the institution and the third party who's accessing your program. Another area that may be easier to tackle, because it's often a category that is pretty similar, are youth camps, athletic camps, music camps. There are a number of these requirements that would neatly apply to most of those camps and programs. When you've got overnight camps, and especially athletics, or band, for instance, where students are engaged very physically, the medical information may apply neatly. And so developing a set of forms and policies and even internal resources for those program staff can be useful and an easy way to address some of the risk. And then sponsored programs. Where are your big, your well-known programs? Are you offering a well-recognized talent and development program? Are you offering a well-recognized Saturday math program? If so, target those first. And in fact, those are the programs that will probably have a lot of these issues already addressed, and that you may be using them as model resources for the rest of your programs as you're trying to roll out the best policies for everybody. So Ashley's going to summarize some of the risk issues and give you some recommendations on supervision.
Yes, in terms of supervision, your institution should be considering implementing an adult code of conduct. Also consider clear contract terms for compliance, not only in the adult code of conduct, but also in other contracts, such as employee contracts. Consider background checks procedures, and whether that's right for you and your institution. Procedures related to travel with minors, that might not always apply to your program, depending on whether students are going to be at a sleepaway camp and they're never going to leave the grounds. Internet policy. Again, you might have a program in which your policy would be more thorough than others. Internet policy for an academic program might be more detailed as opposed to an internet policy for a program like an athletic program where students are not expected to be utilizing computers. Develop guidelines for coming and going. Consider staff and minor ratios to determine whether effective and meeting programs. Develop safe ratios for staff and minors. Make sure you have training on reporting abuse and neglect, and also make sure you have a missing minors protocol.
We're going to go quickly through some of these check boxes because we know there's a number of questions we want to get to, and there's some other considerations I want to address. For medical information, evaluate your requirements and recommendations for immunizations. Involve your wellness staff. If you've got medical folks on campus, use them. Update, develop history, treatment authorization, and medication administration authorization forms. Make sure you're strategic about the medical information that you're asking for from your minors. Ensure appropriate privacy protections. develop related to allergies and EpiPens, and make sure you're able to ensure confidentiality. For behavior and discipline, develop a code of conduct and expectations for minors' behavior and guidelines. Cover things like anti-bullying, sexual activity, and just a note, your Title IX policies are not going to neatly apply to minors engaged in any form of consensual or non-consensual sexual activity. What we see is a common trend where institutions typically prohibit any form of sexual activity, even consensual sexual activity of minors on campus. That's often a more easy way for dealing with this, may be more appropriate, but then of course you may have some more discipline to deal with. Consider internet use. Review your discipline procedures. Consider need for internal guidance for staff. How does staff implement these procedures? And again, this is the whole idea around this is to get away from your code of conduct, which may provide a very detailed process that may not be appropriate in the minor's context, and ensure training. For inclusion and accommodations, it is helpful to have your own accommodations policies for minors. I've seen these, I've drafted them. They don't have to be large, but they can be extremely helpful to the program staff who are getting questions about disability accommodations, so they know what are their requirements, what is available, what do they do when they get these requests in, and how do they go through that process, and also what other institution resources are there and how should they engage, for instance, with experts like your disability services offices. Consider whether transgender and gender nonconforming accommodations is something that you can provide for minors. Is that consistent with what you're doing for your higher education students and your majority age students? And also think about internal guidance for both of these areas and training for your program staff. Other considerations, institutions can adopt a very broad minors policy that tries to address all of these issues. They can also adopt guidelines, and they can adopt policies and guidelines that are specific to each program. There's a lot of ways to slice this, and institutions have to be strategic and thoughtful about what's most usable and helpful to the program staff who are going to be receiving this information. Another thing to consider is insurance for molestation and abuse. If your institution risk managers haven't yet acquired this, they should look for a line on this item. And then you should be requiring it for third parties. Your rental facility agreements and contracts should include an insurance provision. Just as it would have an indemnification provision for third parties, you want to see their insurance requirements covering molestation and abuse. Facility rental agreements, these are for third parties. Consider indemnification language. Is it strong enough? The insurance, are there other insurance requirements you would be expecting that they carry, and are they naming you as an insured? Background checks, are they conducting background checks on their staff who will be supervising minors? Are you requiring them to do that? Are you requiring them to manage that process for you? Adequate supervision, how are they ensuring that they're providing enough staff to supervise the students that they're bringing in, and and how that they're going to comply with institution policies and guidelines. We want to make sure that those contracts are clear on those. So I know we have a number of questions, but I'm seeing that we're at time. I'm going to see if I can, let's see. I think what we'll do is we've got a few questions. Why don't we respond to those individually? For those of you who have not submitted a question and you have one, please feel free to do so, and we will respond to those via email. I want to thank everyone for joining the program today. We hope the information we provided was helpful to you and your organization. If you have not already done so, please click the survey icon at the bottom of your screen to complete our short survey. Your feedback assists us in providing quality future programming, and so we do appreciate you taking the time to fill that out. As a reminder, the program has been approved for Colorado, Illinois, Iowa, Missouri, Nebraska, Tennessee, Texas, and Wisconsin CLE credits. A recording of the webcast will be available tomorrow for watching and sharing. Once available, a link to the recording will be emailed to you along with a certificate of attendance. The recording will be available for 2 weeks. Please be sure to join us for our next webinar on March 8th regarding general data protection regulation compliance. This concludes our webinar. Attending.